The literal rule. This rule is used to so certainty can prevail. As the courts say, certainty in law is more important than individual hardships. According to this rule, courts give terms their simple, ordinary, or literal meaning even if the outcome is not quite practical. In our v. Judge of the City of London Court, 1892, Lord Esher articulated this notion when he said, "If the parameters of an act are simple, then even if they proceed to a manifest absurdity, you will follow them." The court has nothing to do with whether the legislature has committed an absurdity. The rule had been created in the early 19th century and has since been the predominant rule used. In many cases, it has been used, even though the result has made the law nonsense. This is demonstrated in Whiteley v. Chappell, 1868, where the offender was convicted under a section that made impersonating any person entitled to vote an offense. The offender was claiming to be a person whose name was on the list of voters but who had died. The court held that the offender was not guilty as a deceased person is not entitled to vote in the literal meaning of the words. The rule is also opposed because it can lead to arbitrary judgments, as in London and Northeastern Railway Co. v. Berryman, 1946, where a railway worker was killed while carrying out maintenance work, oiling points along a railway track. His widow attempted to claim compensation because the railway company had not appointed a lookout person according to a law under the Fatal Accidents Act. It specified that for men working on or along the railway line for relaying or restoring purposes, a lookout should be given. The court took the words relaying and repairing in their literal meaning and said that the oiling points maintained the line and did not relay or fix, so that the claim made by Mrs. Berryman failed. It is no surprise, especially after decisions such as the two above, that Professor Michael Zander has condemned the literal rule as being mechanical and divorced from the realities of language use. Another issue with using the literal rule happens when a phrase has two meanings or more. Which of meaning should be used can be difficult to decide. The Golden Rule. This rule is an upgrade of the literal rule. The Golden Rule begins by focusing on the literal meaning, but then the court is allowed to ignore an interpretation that would result in an unreasonable outcome. There are 2 points of view about how much the Golden Rule could be of use. First and foremost, it is quite narrow and is expressed in the remarks of Lord Reed in Jones v. DPP, 1962, when he said, "It is a cardinal principle relevant to all sorts of laws which, for no reason whatsoever, you can add to a statutory provision a meaning which the words of that provision cannot bear. If they can have more than one meaning, then you can choose between those meanings, but you can't go beyond that. So the court can only choose between the possible meanings of a word or phrase under the narrow application of the Golden Rule. If only one meaning exists, then that must be chosen." In Adler v. George, 1964, one can see this narrow view of the Golden Rule in effect. In this circumstance, the Official Secrets Act 1920 made blocking Her Majesty's forces in the vicinity of a prohibited area an offense. The accused had actually obstructed HM forces in the prohibited area. They reasoned that they were not liable because the law's literal language did not apply to anyone in the prohibited area. It referred only to those in the area, that is, to suggest outside but close to it. The divisional court found the suspects liable, as it would be unfair if those who caused an obstruction outside the prohibited location were guilty, but nobody inside was. The words are to be translated as being in or in the vicinity of the prohibited area. The Golden Rule's second and broader application is where the words have only one precise meaning, and that meaning would result in a repugnant case. In such a case, the court will bring up the Golden Rule to change the legislation's words to avoid this problem. A prime example of this was the case of Rhys Sigsworth, 1935, where a mother had been killed by her son. The mother had not prepared a will, and her land should normally have been inherited by her next generation, according to the rules laid down in the 1925 Administration of Estates Act. This meant that the murderer's son would have inherited as her issue. There was no confusion in terms of the act, but the court was reluctant to allow a murderer to profit from his felony, so it was held that the literal rule should not be enforced, and the Golden Rule would be used to avoid the inheriting son's repugnant circumstance. Indeed, the court wrote in the act that the issue would not have the right to inherit where they had murdered the dead. The Golden Rule respects Parliament's exact words, except in limited circumstances. The golden rule offers an escape route, where there is a problem with using the literal rule. It enables the judge to choose the most rational meaning where the words in the act have more than one meaning. In cases where the literal rule would lead to a repugnant situation, it can also provide rational decisions. It would certainly have been unfair to permit the son to profit from his crime in Re Sigsworth. That demonstrates how it can avoid the literal rule's worst problems. It is very limited in use. Therefore, it is used only on rare occasions. Another problem is predicting when courts will use the golden rule is not always possible. It was described by Michael Zander as a feeble parachute. It's an escape route, in other words, but it cannot do a lot.